demand.
Mr. Tutt, what you say is compelling in a lot of ways, but your friend on the other side is going to say Gasparini, and that there the court did this crack and extract thing and took what they could of it and ditched what they couldn't. What do we do about Gasparini from your point of view?
Well, so the court determined in Gasparini, the court majority determined that there was no direct conflict with Rule 59. That Rule 59 provided a mechanism for the enforcement of the substantive New York standard for reviewing excessive jury verdicts.
Right. How would you have us distinguish it, is my question.
So we are a direct conflict case. So we are a Shady Grove case where, because a federal rule unavoidably conflicts, you don't get to the murky waters of Erie, which was
So you think Shady Grove, properly understood, and I think you're embracing even Justice Scalia's opinion that's not for the full court, says once we're in federal rules of civil procedure land, we're not going to play with Hanna, we're not going to play with Gasparini. Is that a fair summary of your position?
Yes, that is exactly it.
And certainly there are some judges, Judge Ferguson and others, who would have us adopt such a rule. I appreciate that. For the simplicity's sake for district courts. Can I just turn real quick to your Rule 11 response, because your friend on the other side makes a big deal out of it, and you say, well, it's distinguishable because it only speaks to federal statutes. And he's going to get up here, I know he's going to say, well, look at the original federal rules of civil procedure. They expressly distinguish between federal statutes and statutes simpliciter. And therefore, when we see statute simpliciter, as we do in Rule 11A, we should encompass states. You know the argument. Okay. And assuming there's some force to that, do you have some other argument? For example, could one say that 11A has to do with pleadings and verifying the pleading, either the attorney or the plaintiff, defendant, whatever, has to verify the pleading, and an AOM ain't any of those things?
Absolutely, Your Honor. We could have developed this argument more in our reply brief if we had more words.
I wondered, yeah.
But there is a contemplation that, an affidavit and a verification have an understood meaning in federal court. And
with respect to pleadings, which that word is in the rule.
Yes, Your Honor.
And is an AOM a pleading?
Yes, and an AOM,
it's not by one of the parties. I mean, it's a third party document.
We concede it is not literally a pleading, although we think functionally, actually, they're trying to smuggle in the idea that you have to have a doctor come in and essentially vouch for you in your complaint. But I agree with you that it's not what we expect to see when we talk about verification of a complaint, or we talk about an affidavit in support of a complaint, which is designed to support the allegations therein by the actual pleader. This is, I have to go get an expert witness who has to be a specially qualified person, a very precise person.
He's not pleading for you, he's an expert witness.
Right,
Thank you.
Yes, sir.